Hello. In this clip from our Justia webinar, Logic for Lawyers, Crafting Persuasive Legal Arguments, Ryan McCarl shares his thoughts about why procedure matters and how it can be overlooked while working on your legal arguments. If you want to see more Justia videos on law practice and legal marketing, be sure to subscribe to our channel.
I think one of the reasons my book has resonated with a lot of practitioners is that I am one. So like many of you, I was up late writing filings. I'm preparing for trial. And I think when you're in the trenches doing that, you are have maybe a little bit more heightened awareness of how much procedure matters. And if there are any law students or new lawyers listening, I can tell you that one of the ways that you can make yourself the most useful to a litigation team is to just become fluent in the relevant rules, the court rules, the judge's rules, the civil procedure rules for your forum, and the evidence rules, and so on. If you are an encyclopedia of rules who immediately knows which one applies in a given situation, it's going to be hard to get rid of you because you'll be so useful. So how does procedure affect legal reasoning? And I'm going to explain here in the next couple slides. So litigation arguments are shaped by their procedural context. So everything that we just discussed in terms of legal syllogisms was all about substance. It was all about whether the elements of battery were met or the elements of a speeding ticket are established. So, but both of those examples are abstracted from any kind of procedure, and that is how, that's how IRAC often is done. When you teach legal writing courses, there's often sort of a set of facts that is taken as given because there's not going to be any kind of evidentiary workups. The facts aren't usually given in that way, and the available facts are rarely, are going to vary based on the motion in each instance and based on the particular case's state, based on findings that have occurred, admissions that have occurred, and so on. So really the set of available tools that you have to argue with changes with each procedural step in a litigation. So some of the facts, some of the procedural aspects that affect making what arguments are effective are the case state, like I just said, default rules, which means what happens if nothing happens. What is this? Who wins? The tiebreaker goes to whom? For example, a default in civil litigation occurs when one side doesn't show up, but if the suit doesn't occur, then the default rule, the status quo, is going to be that wherever the particular rights or money are held right now, whoever's bearing the relevant costs is going to continue to do so. So when a plaintiff files a suit, they're trying to switch that, move away from that default, and every motion is essentially an attempt. Almost always the moving party who has an obligation is the one with the burden to show an entitlement to relief. So they're attempting to move the procedure off of a default that would apply if the motion was never filed, and they're trying to change the case state going forward. And then, as I alluded to a moment ago, depending on the procedural posture of a motion, you may face evidentiary constraints and constraints about which law applies. So I've come across in my study of legal reasoning some terms such as current fact situation or argument situation that try to capture kind of the set of available premises, factual premises and legal premises, and kind of put them on the table as what you can use to craft an argument. And I find those kind of terms to be pretty unwieldy. So I've started using the term bout to sort of visualize the procedural and substantive combined situation that occurs when you fight over a motion in civil litigation. So best to explain by example here. So for example, a defendant moves to dismiss under Federal Rule of Civil Procedure 12b-6, which is as a tool to say that even if everything in the complaint is true, the plaintiff doesn't have any legal remedy. So there's these different variables that we talked about. Here's what they look like in this situation. You have the case state. This is usually early in the litigation where there's not there haven't been significant rulings, no facts have been found. So your universe of facts is going to be the facts that are alleged in a complaint or are sort of objectively verifiable by the judge and therefore may be subject to judicial notice. For example, statements in an opponent's pleading. Available rules. The actual 12b6 standard doesn't shed any light on how to apply it. So, you have the general Supreme Court on down precedents of how this rule operates in practice in a more granular way. For example, legal conclusions are not treated as facts. That must be assumed true. The facts alleged must be plausible to be assumed true, and so on. And then at a more granular level, when you're selecting which cases to argue about, the further afield you get from cases that are decided in this context of challenging a pleading, the more risk you run of selecting something that turns out not to apply. So if it's out, you always want to find authority that is decided in a similar procedural posture or one that's even less favorable to your side. Otherwise, it can be pretty easy to distinguish. Then you have the default rule and tiebreaker. So who wins if nothing happens? And the answer is that the defendant filing the motion to dismiss loses, and the plaintiff is allowed to proceed. And that is, in fact, how most motions to dismiss turn out. So, and then finally, who has the burden and what's the relevant standard? Again, the defendant has the burden, and what they're required showing is that the facts plausibly alleged, if true, wouldn't entitle the plaintiff to relief under any theory. And what I want to emphasize here is that these variables constrain the legal argument by constraining the available premises and the available arguments. So whenever we talk about legal syllogism or other models for arguing about substance, it all occurs in practical litigation within a procedural game or bout like this. I've started using as my mantra, I criticize IRAC and CREAC for many reasons, and of course people want to know what's an alternative. Well, my simple mantra that I teach is conclusion plus reasons. So in other words, you state your desired conclusion, and then you provide reasons, sufficient reasons to support it. And they may be perhaps each reason is sufficient in itself. So these are fallback arguments. If one fails, we have another one and then another one, or perhaps they jointly work together to strengthen an inference that the conclusion is true. We'll talk more about how to design these reasons and select them and flesh this idea out a little bit more. But the idea of starting with a conclusion and then backing it with legally cognizable reasons is really the key move in writing effective arguments. Most premises are linked. So this goes back to the examples of the examples that I talked about of conclusory statements in which you have a rule and then a conclusion. The rule statement by itself, just like a discussion of a case by itself, is not going to be a reason because it has to be intertwined with the facts of the case. So the rule and the facts operate as joint premises, both of which you need to create a reason. Here's a diagram explaining, kind of showing how this works in practice. So suppose that in a personal injury case, the plaintiff needs to prove that somebody ran a red light, the defendant ran a red light. So there's two linked premises. You put a witness on the stand to testify to that effect. The witness testifies that the defendant ran the red light. And there's another premise that may need to be established, almost certainly does, and this is what lawyers call foundation, is that the witness was in a position to observe whether they ran the red light. If they were out of town, not much weight's going to be put on their assertion that the defendant ran the red light. And that there's an inference pattern from it's called argument from a position to know. The witness was in a position to know whether the defendant ran the red light, and the witness says that is what happened. So presumably that is what happened. Presumably the witness testimony kind of puts a stone on the scale, making it more probable that is what in fact what happened, and it's going to have the effect of sort of shifting the tactical burden or the temporary burden to the defendant to put up their own witnesses or otherwise challenge this testimony. And one way they can do so is by challenging the inference itself by bringing in additional information. For example, I have here at the bottom of the chart, witness is blind. This is called an undercutter. It undermines the inference from the premises to the conclusion. So, the couple of key ideas here as well. So you have, I'll just mention one. I think the others I've made clear enough. But with defeasibility, the one of the problems with importing the model of syllogisms to the law is that in deductive logic, where the concept of a syllogism originated and exists, there's sort of a certainty to it. So the idea is that you take the premises as true, and therefore it follows as a matter of logical necessity that the conclusion occurs. But that's just not how it works in almost any legal situation. All that you get in most legal arguments is a increased probability of the truth of the conclusion. Or you may get sort of a burden of production being met, as in this instance, when you put the witness up and they testify as such, and that's presumably the outcome. However, the conclusion is defeasible, meaning that there may be other ways that the defense can challenge that conclusion by putting on other witnesses who say the opposite, for example. So rarely are conclusions fixed in the law. They're usually subject to challenge and only provisionally held.
Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please hit the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next clip.